Well, hello, my true crime junkies, who I lovingly refer to sometimes as boonies, but not in the way everybody thinks. The hearing on Thursday really was, it was quite the review of what we're going to be seeing when they go to trial on October the 7th. Usually, when I'm live streaming, there's so much going on, and it's hard for me to pick up every single thing. And I know sometimes when there's that many things going on in a hearing, it's also hard for you guys to stop and go, okay, let's look at this piece. I thought it would help me, and also maybe you, if we pieced out each of these motions and looked at them a little bit closer. So let's get to it.
Judge, as you know, I filed on behalf of Sarah Boone this motion for statement of particulars by an act eminently dangerous to another and evincing a depraved mind regardless of human life did kill Jorge Torrez. Judge, that's about as bare bones of an information as you can file in a case. I know anytime there is a weapon used, it's usually shot with a firearm that was used, that type of language. That is as bare bones. It doesn't even spell out all the essential language of the jury instruction.
So basically, guys, in a nutshell, James Owens is going in and doing his job, I guess you would say. He wants them to be more specific about what Sarah's charges are. Y'all know what this reminds me of? This reminds me of Daryl Brooks. Who remembers this?
Can anyone make a claim against me? Can you make a claim against me, Your Honor? So who makes the claim?
I don't understand the nature and the cause of the charges.
There is no language in the information that alleges what criminal act Sarah Boone committed that caused the death of the victim, Mr. Torrez. But the state, in their charging document, has failed to say exactly what it is that they believe is the criminal act that caused the death by Sarah Boone.
Okay, well, I don't believe that the jury is going to have a problem figuring out exactly what the prosecution is claiming. I think it's going to be pretty damn clear once they see that video, which we know, Mr. Owens, you too have seen that video. I know there's a lot of videos. I'm referring specifically to the infamous 2 Suitcase videos.
We have no information, no particulars in the information that explains a series of related actions arising from and performed pursuant to a single design or purpose. None of that language is in the information that would let us know what it is they're claiming that she did or series of acts that she committed that constituted the cause of the death of Mr. Torrez.
Mr. Owens, do you want ranch or blue cheese with that word salad?
The definition goes on to explain that an act is eminently dangerous to another or demonstrating a depraved mind if it is an act or series of acts that, one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. What is the act or series of acts that an ordinary person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury?
I would think that when someone is in a suitcase all zipped up and they're saying, I'm serious, I can't breathe. Wait, do we need to play that video? I don't think we need to play that video. I think we've seen that video enough.
2 is done with ill will, hatred, spite, or evil intent.
Okay, we do need to play that video. I just have to watch this to see there was some ill will and some intent.
Sarah.
For everything you've done to me.
Sarah.
For everything you've done to me.
Sarah.
Fuck you.
Sarah.
Fuck you.
Sarah.
Stupid.
Sarah.
That's my name. Don't wear it up.
Sarah. I can't fucking breathe, babe. Seriously.
Yeah, that's when you do when you choke me.
Sarah. 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 Sarah, I can't breathe, babe.
That's on you.
Sarah, I can't breathe.
It's on you.
Sarah.
Real or ransom. Might want to get video for it extra. Because I got this.
Sarah.
Real or ransom.
Sarah. Sarah, I can't breathe, babe.
Oh. That's what I feel like when you ching on me.
Sarah.
Fuck
I
you.
can't fucking breathe, Sarah.
Yeah. You should probably shut the fuck up.
Sarah.
Shh.
And 3, is of such a nature that the act itself indicates an indifference to human life. Again, some explanation that give the defense, my understanding of the rule of criminal procedure, the defendant has a right to know the charges against them with specificity. Upon request, the state must provide specificity and clarification on the details of the alleged offense in order to minimize surprise at trial and ensure that the defendant's rights are protected. In this case, based on the bare bones information that has been filed in this case, it fails to inform the defendant and the defense counsel of the particulars sufficiently to enable the defendant to prepare a defense. Thank you.
Judge, the state stands by its written response that was filed on September 5th of this year. Is the position that it's an extraordinary remedy to be given a statement of particulars in a case. The information in this case tracks the statute. That is what is required. There is nothing confusing about it. There aren't multiple allegations of second-degree murder on the same day, leaving her confused as to what we are talking about. There is no exposure to double jeopardy. There's no element of surprise. The state of Florida
Definitely no element of surprise.
has provided discovery to the defendant in 2020. The state waived any opinion work product arguments that it had under Williams versus State in going ahead and providing the defendant exactly which exhibits we're going to enter in a trial, exactly which of the witnesses we've disclosed will be called at trial. And their motion does not set forth why it is specifically that they don't understand what she is accused of doing and how. In fact, opposing counsel cited the videotapes, the videos that were taken on her phone while the decedent was in the suitcase begging to be left out. And then what they didn't mention is what she said during these videotapes, which certainly would constitute the mens rea for second-degree murder. So it's our position that they have not stated why it is that a statement of particulars is necessary. There are informations and indictments that span years that don't get statements of particulars articulated to the defense. In this case, the date is specific as to February 23rd, 2020. The metadata on the two videos that were taken from her phone are both from the 11 p.m. hour of February 23rd, 2020.
I think at one point I remember Owen said, "Oh, I don't know if it was the 23rd or the 24th." I thought about that after he said it. And I was like, wait a minute, because it does get kind of confusing. We haven't seen the full ME report. We've seen portions of it, but they would have seen it already as the defense because, like he's saying, prosecution has already turned it over to the defense.
Given all the discovery in the case and the amount of narrowing down that we've already done, there is no need for a statement of particulars in this case. Thank you.
Exactly.
Thank you. Any response?
My understanding of the law is the court has broad discretion on this issue about whether to require the state attorney's office to give more particulars about the offense. And this is somewhat of a unique case. Judge, I'm sure you're aware that Mr. Torrez suffered from some blunt force trauma that was unrelated to the death. The medical.
And this is the part that just blows me away. He brings up stuff about George's injuries that just basically say that he has seen the ME's report.
Medical examiner who did the autopsy took photographs and described that there was blunt force trauma on Mr. Torres's body that did not cause the death, that was unrelated to the cause of death.
Exactly. So we know it was only him and Sarah in the apartment. Therefore, you know what I think, guys? I think that what James Owens is doing. Now, remember, he's not used to practicing in this area of Orlando, Florida. He's usually over in the Panhandle, pouncing around in the Pensacola area, right? He knows all those people over in that courthouse. And as Sam had said earlier, you know, he may not be able to get away with the things that he got away with over there or gets away with over there. He's in a whole new area. To me, he's having batting practice. And if you don't know anything about baseball, before a game, all of the players come to the field, they stretch, and they have batting practice 2 hours before the game, at least 2 hours before the game. That's what James Owens is doing. He's looking at his competition. He's testing his competition. He's testing the judge to see what the judge is going to say and how the judge is going to respond to some of the things he's doing. And I really do feel like he's kind of like dipping his toe in to go, how's this going to flow? Because this particular motion right here is such crap that it's just stupid. It's just stupid.
And that information has not been detailed, whether or not it's relevant to his death, whether or not they're going to try to tie that in to Mr. Torres's death. And if not, if we're relying on the medical examiner's explanation of the cause of death, which was asphyxiation, suffocation, then there's a question about whether that information is.
But is there anything that's missing under the statute? I understand your reliance on the jury instructions, but what's your response to Mr. J's position that it tracks the language of the statute wholly and completely, which it seems to?
Well, I have the rule for motion of particulars then. If that's the case, then in every case in the country, you just have to track the statute. And at no time a court would ever order a motion for statement of particulars.
But the date's there, the time's there, where it happened is there, the underlying charge is there.
I understand. And I explained that this is not a shooting where death would occur fairly quickly after multiple shots, that this was an unusual death, asphyxiation over a period of time, which we don't even know whether it was the day before or the next day. There's questions about that. The injuries, the blunt force trauma that the medical examiner is claiming that they're there, I believe is going to testify they could have been there 24 to 36 hours before. We don't know when those prior injuries were. They're fairly fresh, but they can't state that they were close to the time of death. Again, they weren't related to the cause of death. So there are situations in the law based on the unique set of facts that a court feels compelled, yeah, I have the discretion and I feel like for the defense to properly prepare for this case due to this unique set of facts that I think there are some details that you must give. There's blunt force trauma. We don't know exactly when it was. We know it was fairly recent. And the medical examiner says the cause of death is asphyxiation. He doesn't know if it was environmental or not. He gives two explanations. So there's a real question about that. And of course, we'd like to know what theory they're going under and whether or not they're intending to introduce evidence of this blunt force trauma that occurred sometime prior, and what exactly they're claiming that she did that constitute. Is it just the video, the 2-minute video that everybody's seen, or the suitcase video? Is it that? Because there was a lot that occurred prior to the video. There was a lot that occurred after the video that's not on the video. So is that what they're referring to in this narrow window of?
Yes, we would all like to know what happened before and after that video. We've all been sitting here waiting on pins and needles to hear Sarah tell the truth as to what really happened. Because all we have right now is a timeline from cell phone documentation, public's receipts, and neighbors' accounts of what they heard.
Thank you.
All right, thank you, sir. if the indictment is sufficiently full in its allegations of fact constituting the crime charged to enable a person to plead to it. The greater part of the reason for allowing particulars does not exist. The application was not so much for a bill of particulars as for a detailed statement of the evidence by which the state proposed to prove its case. If the defendant was advised of the nature and the cause of the accusation against him and had notice of the dates on which the acts constituting the offense were committed, there was no necessity for the bill of particulars. All this information was given in the indictment. It sounds like, based on your argument, you're looking for the particular evidence as to the cause of death and the meaning of the death, which, based on Peel, is not something that falls under the ambit of a motion for particulars. So reliance on State v. Peel, understanding the age of this case as well, understanding there have been multiple lawyers who have filed responses denying the charges in their notices of appearance, your motion is denied, looking at the totality of the circumstances.
And you just got
Cranicked.
Sir. Welcome to Orlando. Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.